In our other ICJ lecture series, we focus on events, topics, things relating to what is going on or has been going on in the ICJ, International Court of Justice. So we will focus today, this afternoon, also on the international law aspects, international legal aspects involved in especially the two latter cases or situations where the ICJ has dealt with nuclear weapons, as well as with arms control law, as well as with a topic which was at the heart of especially the last one, the Marshall Islands case, which is actually called Obligations Concerning Negotiations Relating to Cessation of the Nuclear Arms Race and to Nuclear Disarmament, which is indeed about negotiations. I'll say a little more when I introduce our three speakers. As I said, we will focus on the two last issues dealt with by the ICJ, the advisory opinion on the legality of the threat with use of nuclear weapons, the advisory opinion of 1996, and the case I had just mentioned with a very long title, which is usually mentioned as the Marshall Islands case. And that is also basically because we have the fortune and the privilege to have with us someone who was involved in the two advisory opinion and the Marshall Islands case, which is our first speaker, Mr. Van der Biese. He is a lawyer from a law office in Amsterdam, Van der Biese Kloostra, and as you have seen in the announcement, he was the co-agent together with the Minister of Foreign Affairs of the Marshall Islands in that case. He was also very much involved in the organization, the leading up of the advisory opinion as Vice President of IALANA, which is an NGO, and Lawyers Against Nuclear Arms, which lobbied with other NGOs very strongly, which resulted in the end in the question asked by the General Assembly to the International Court of Justice about legality. Paul van der Biese started his career, I should say, in what we call in the Netherlands the sociale advocatuur. Let's say pro bono lawyering in the Netherlands, but then also very quickly already focused on international environmental law, for which he did many interesting cases both in the Netherlands as well as internationally. Overlap international, national and European law. As I said, he was involved in the, but he'll say much more about that in his presentation, involved in the leading up to the advisory opinion. But then, between the advisory opinion and the Marshall Islands case, he was also the deputy agent for Bosnia and Herzegovina in the genocide case before the ICJ against Yugoslavia. He was a representative of Djibouti in also a very interesting case against France. And is a practicing lawyer also in not only in case in the Netherlands but also in the European Court in Luxembourg and also in Strasbourg. As I said, he will speak and focus on the two cases that he was involved in. Of course, you will remember, but I'm certain that Mr. Van der Biese will mention that there has been another case, the nuclear test cases, Australia and New Zealand, which we'll only deal with in passing. So, Paul van der Biese will focus on the issues leading up to the advisory opinion and the Marshall Islands case, the issues involved, which the international legal issues we will focus on. And then our second speaker will follow up with a focus on the international legal aspect of arms control. Professor Erik Meijer, Professor Emeritus in Utrecht, where he had the chair of conflict and security law. He's still director of the Center for Conflict and Security Law and co-editor of a journal you all know probably, the Journal of Conflict and Security Law, Oxford University Press, which he edits together with Nigel White and Robert Cryer. He is, as I mentioned, an expert in conflict and security law. Arms control law is especially a specialization. The use of force, the law of armed conflict, a long-standing member of the ILA Committee on Use of Force, and also well known for his book on chemical weapons. In fact, he has a history in chemical weapons, so to speak, as a former delegate of the member of the Netherlands delegation, which led up to the creation of the OPCW. OPCW not far from here. As I said, so we will move from the international law aspects of the advisory opinion and the Marshall Islands case, the question about the obligations under treaty law, customary international law, etc. Then we move on. Hear what Professor Mayer has to say about arms control law in relation to those issues. And one of the issues, as I already mentioned and you already know, is the issue of the obligation to negotiate nuclear disarmament. And as it so happens, our third speaker is Mr. Kees Nederlof, who is now retired but was the Netherlands ambassador for nuclear security until his retirement last year. He represented the Netherlands as the international coordinator of the global initiative to combat nuclear terrorism. He was a so-called Sherpa, as it was called, in the Nuclear Security Summit, and also served as in all preceding phases of the Hague Nuclear Security Summit, and was involved in the European Union mission and activities in nuclear affairs, and also a deputy permanent representative in the International Atomic Energy Agency. That order, we will have Mr. von der Biesen first, followed by Erik Meijer, followed by Kees Nederlof, after which we will have plenty of time for questions and comments from you. And I already see a few faces here in the audience who know a lot about these issues, so I think we'll have a very interesting evening. When you're ready, Mr. von der Biesen, now as you take the floor, Mr. von der Biesen will speak from here. He will have a PowerPoint which is already coming up.
Thank you. Thank you very much, Olivier, or should I say Mr. Olivier Ribbeling, for this introduction. I am a lawyer in Amsterdam, as Olivier mentioned. I am what we call these days public interest lawyer, and I'm usually representing civil society organizations and the like, and in that capacity I've been litigating a great variety of cases before a great variety of courts. Let's see. Okay. It makes a sound to begin with, so that's good. Okay. Sorry. This one right here. Sorry about that. So this is the topic. It's part of the topic that I've been working on for quite some time, and it's in the end all about the devastation that will be brought about once a nuclear weapon would be used. And as we all know, nuclear weapons have been used only twice during World War II in Japan, and the consequences of that are still visible and are still being felt by several generations in Japan. the same is also true for people that are living in areas where nuclear testing has been taking place. Also there, the people around those areas do still feel, even if it's decades ago that those tests have been taken place, the consequences of those tests. I'll come to speak about that later on. The important features of nuclear weapons are that they have an enormous power, of course, in the first place, which in itself makes it very difficult, if not totally impossible, to, when used, make any difference between combatants and non-combatants, between military and civilians. Another feature of nuclear weapons is the enormous heat that is caused by the explosion, the enormous blast that is caused by the explosion, and very importantly, the radiation which continues to be active for decades after the use of these weapons. And radiation also causes victims decades after the actual use. Nuclear weapons cannot make a difference, are not able to make a difference between combatants and non-combatants, and that is, from a legal perspective, one of the very important features that really make a difference. I didn't know anything about nuclear weapons until during the 80s in the Netherlands, as in many other European countries, the issue of a possible deployment of nuclear cruise missiles became important. The idea was that nuclear cruise missiles would be deployed in several Western European countries, and the people living in those countries were very much opposed to that, and that opposition led to hundreds of thousands of people taking to the streets, which is for the Netherlands a very exceptional amount of people demonstrating against an imminent danger. And during that time there were people who asked me, why don't we bring the state of the Netherlands to court to prevent the deployment of nuclear cruise missiles in the Netherlands. And that was my first encounter with international the international relevance of opposition against nuclear arms, and also the international legal aspects of that. We had a crowdfunding system to finance the case, which was a sort of crowdfunding avant la lettre, because we decided to have as many plaintiffs as possible in our case, and asked all of them on a voluntary basis to contribute 25 guilders at the time per person, and that was very helpful and remained helpful for many years of litigation. So that brought me to the district court in The Hague in the period of time that I was forever young, as you can see, together with a colleague of mine, and Peter Engelse, who later became a judge in the Court of Appeal in Amsterdam. We did the litigation, the two of us did that with the help of one student of international law. I won't go into the details of that case for very long. Sorry about this. But I'll just briefly tell you the history of it. We submitted the writ of summons in November of 1984. In 1986, the district court said it had no jurisdiction because this was a matter for for politics and not for lawyers. Sort of political question doctrine, which is accepted in the United States case law, but which is totally unknown in the Netherlands. And in appeal, the Court of Appeal made that very clear. It quashed the initial judgment, but also dismissed the claims because it said deciding on the legality of a treaty is a matter for the Parliament, which is, in other words, exactly the same thing, and that was referring the issue to the Parliament, which was clearly wrong, as well as the Supreme Court decided in 1989 when it quashed the judgment of the Court of Appeal, and when the Supreme Court then went on to take care of the case itself, which was in itself exceptional, because usually the Supreme Court should have referred the case back to another Court of Appeal, but it didn't do that, and it decided that there were enough facts available for the Supreme Court to come to a decision, and the court decided that not at all, in all situations, a use of nuclear weapons would be illegal under international law, and therefore the case was dismissed, which was a disappointment, of course, but it was also an exceptional sort of judgment. In the Netherlands, I said there were lots of people opposing the deployment of cruise missiles, but that happened in other European countries as well, and it turned out that in that area, in that era, many lawyers became to be involved in litigation on nuclear issues. Actually, we got, except from this one student that we had as a researcher to assist us in that litigation, we also got in touch with lawyers across the world, mainly from the US, the United Kingdom, France, and a handful of other states that were all at the beginning of inventing litigating on nuclear weapons, and that was very helpful. And these lawyers decided in '88 to bring together the experiences of us lawyers from across the world, and we founded the International Association of Lawyers Against Nuclear Arms. And during the first years, sorry about this. The ILANA headquarters were in The Hague, across from the International Court of Justice. And it was run from the Netherlands for some 10 years, and now it's run from another place, a combination of Berlin and New York. So that was, we were getting some knowledge, some experience, and some power in that sort of litigation. I was asked in that time to represent some people that were actually hurt by the French nuclear testing in Mururoa, which was in the 90s. I won't go into the details of that case, but it was a case that we brought against the European Commission, and which was declared inadmissible by the President of the Court in Luxembourg because of the peculiar rules for admissibility that are still in place under European Union law, which makes it almost impossible for citizens of Europe or civil society organizations to bring cases against the European authorities before the courts in Luxembourg. But it was a serious case about people that got hurt and physically sick as caused by the nuclear testing of France in the 90s. Olivier just mentioned the two nuclear test cases that were brought before the International Court of Justice. That was in the 70s already, and as you will see, all of the nuclear weapon cases before the International Court of Justice had some peculiarities in their outcomes and caused a lot of commentaries from learned academics on these rulings of the court. This was also true with the Australian and New Zealand cases against France. There were all sorts of preliminary objections raised by France, not in a formal manner, but by letters that it wrote to the court. But in the meantime, on the international level, all sorts of communications and maybe even negotiations went on, which led to France deciding that it would stop its nuclear testing. It did not inform the court formally about that, but announced that by a press release, and the court sort of proprium motu decided that then the cases could be stopped, actually ended, because it decided that the cases had gone moot because of the decision of France, and therefore there was no reason to continue with it, which was very practical in a way, obviously, but it seemed that Australia and New Zealand were not very happy with that very sudden unilateral sort of decision of the International Court of Justice. I wasn't even a lawyer by then, so I've not been involved in those cases. My involvement in the international cases on nuclear weapons started actually with the Bosnian case. As you know, Bosnia and Herzegovina brought this case against then the former Republic of Yugoslavia before the International Court of Justice, and this was in the midst of, or at the very beginning of the Balkan Wars in '93, in an effort to stop the war from further escalating. At that point in time, a professor of international law, who was also involved in the International Association of Lawyers Against Nuclear Arms, had the idea, together with the Bosnian ambassador at that time in New York at the UN, to bring this case before the International Court of Justice. And this American professor of international law called me one day with the simple request, can I use your office when I'm in The Hague, because I'm bringing this case. And of course, this was in the midst of this war that was escalating. And I said, whatever, I'll carry your bag, I'll do anything to be of any sort of help, because I think everybody in the Netherlands and in a large part of the world felt very helpless by this war that was ugly in the beginning, and it became even more ugly when it continued. So everybody wanted to help, and so that was my first step in the International Court of Justice as a sort of help for this professor Francis Boyle. And later on, that's a story that I won't spend any time on, but later on the Bosnian government asked me to put together a new legal team, and they parted with the American law professor. And from that point on, I was in charge of the Bosnian case, so that gave me some sort of experience before the International Court of Justice. As you know, the court has two functions: the contentious cases function and the advisory opinion cases function. Advisory opinions that can be asked by several selected UN bodies. All of this is to be found in the Charter, of course. And the possibility that a case could be brought before the court through a request of an advisory opinion brought these lawyers from Ayalana to the idea to see whether there would be any states interested in asking a request for an advisory opinion through the General Assembly. And that idea picked up rather quickly, I must say, and also among civil society organizations, and that evolved into what was called the World Court Project, and that became a sort of a movement of civil society organizations that were lobbying various states, governments, to support a possible resolution that would be brought to the General Assembly to ask for this opinion. And when the non-aligned movement, which was at the time a very important international movement of states that were not part of the West and not part or didn't feel to be part of the East either, and tried to stay outside of the Cold War, they had at the time still a sort of influence and were a large group of states. And when they got convinced about the civil society, by the civil society organizations, that this would be a good idea, they had by themselves already a majority within the General Assembly of the United Nations, and they submitted the resolution proposing the questions that could be asked to the International Court of Justice. And of course the Ayalana lawyers played a role in formulating these questions. That took some 3 or 4 years before that resolution was accepted. Hundreds of organizations were involved, millions and millions of handwritten signatures were delivered at the International Court of Justice. The registrar told me that they're still covering the cellars of the building, and they still keep them, so that's very nice for history purposes. And it became a case where some 40 states were actively participating in the litigation of the advisory opinion, which of course is a little bit different than contentious cases, but it's got both a written round and a oral pleadings round, and in the oral pleading stage some 25 states appeared actually before the court and took part in the pleadings. And the Ayalana lawyers had an office in the Indonesian embassy at the time. Indonesia was, I think, heading the non-aligned movement at the time. And in that office we had meetings every day to support lawyers from countries who didn't have a strong ability to prepare legal briefs and presentations for the pleadings. So that's where we could be helpful in preparing these pleadings, the oral pleadings. The opinion of the court contains an extensive analysis of all the law that had been presented to the court as being relevant international law. There were many states that presented environmental law as part of the argument, but obviously the emphasis was on humanitarian law, and obviously a lot of emphasis was given to the factual features of nuclear weapons, and also of the particularities of the strategy for the nuclear cruise missiles were explained to the court. And well, all of that resulted in this advisory opinion, which as its most central finding is the finding which is also, let's say, a bit controversial, but it has all sides of the argument present in the section of the finding that is here on the screen. Most importantly, it says that any threat or use of nuclear weapons would generally be a violation of the rules of international law, applicable in armed conflict. Also, in the opinion itself, the court had already explained that use and threat of use are, from a legal perspective, the same thing. So a threat of use should be treated on the same legal basis as use itself, which is different, a threat of use, than only the possession of nuclear weapons. But in any event, that was a finding of the court, and here it says that the possible use of nuclear weapons would generally be contrary to the rules of international law applicable in armed conflict. Then the however part of the finding of the court comes, which has been, I think, by many people, many politicians, been misused. The court says that it could not give an answer to the question whether the threat of use or use would also be unlawful or lawful in an extreme circumstance of self-defense, in which the very survival of a state would be at stake. It was interesting that the court came up with this part of the finding, because this was not really presented as an argument by any of the nuclear weapons states. But apparently the court came to a point where it said where it didn't want to reach or couldn't reach the very final stage of its findings, which is given in the first paragraph of this section of the opinion. I remember that Mr. van Mierlo, our Minister of Foreign Affairs, when asked about his opinion on what the court had found in this advisory opinion, said, well, it's only advisory, so we don't have to worry about it. And that was an easy way out. It was not really a way out, but it worked, because the people who were asking that question didn't know what to respond to that answer. But apart from that, on the international level, many people in governments took this position. This is only an advisory finding, and that is, from the perspective of the International Court of Justice and the case law of the International Court of Justice, obviously wrong, because any finding, be it in an advisory opinion or in a judgment in a contentious case, for the court has the very same value, and there is no difference in weight between findings in a contentious case and advisory opinions. You can notice that also when the court, in its judgments and advisory opinions, frequently refers back to its earlier case law, and there is never ever any difference in the references that the court makes to its case law in advisory opinions or in contentious cases. So these findings of the court, whatever one may think of it, and whatever the real strength of it or lack thereof, is, because it's an advisory opinion, not any lighter, not any weaker than a judgment in a contentious case. This part of the advisory opinion has encouraged academics to write about it and to be very unhappy about it, because it's, as it is called, a non-liquid. The court says we don't know, we cannot rule on this part of the question, which has been attacked by people who say, well, there was enough factual material to come to a conclusion, and others said that would have been or should have been a reason for the court not to begin to answer the question at all. If this would be the outcome, then it should just have said and argued, we are not going to do this and then that should have been apparently some political motivated reasons for it. It's oh, sorry. This book is. It says it's about international law and the International Court of Justice and nuclear weapons. It's almost exclusively about the advisory opinion, and it really contains all sides of the argument and all sorts of very different views of legal scholars about the nature and the value or the lack thereof of the advisory opinion. There is one part in the advisory opinion which became very important, or was better, was the very reason that a case for the Marshall Islands seemed to be possible at all. The court, towards the end of its findings in the advisory opinion, was a bit tired, frustrated, hopeless about the fact that there were on this very important issue such opposing opinions. And it said in the advisory opinion that this situation could not continue, would not be good for the world, it would not be good for international law. And it said it is consequently important to put an end to this state of affairs. The long-promised complete nuclear disarmament, the court said, appears to be the most appropriate means of achieving that result. And there the court started out an analysis of the Nuclear Non-Proliferation Treaty, which was interesting because the court there started to answer a question which was not put to the court, but it just by itself decided this is where the way to go for the world. It focused on Article 6, the nuclear disarmament provision of the Non-Proliferation Treaty, and it produced an analysis of the meaning of that treaty, especially of the nature of the obligation to negotiate nuclear disarmament. The court said this is not just an obligation of conduct. This is not an obligation to do your utmost best and to try and bring nuclear disarmament to a success. It said the court found that this is an obligation of results, which means there is an obligation to come to a treaty that is outlawing nuclear weapons. And the interesting part of the opinion, I think, is that this is a finding of the court that is unanimous. At the same time, it's a finding which is remains a bit vague as well, because it says there exists an obligation to pursue in good faith and bring to a conclusion negotiations leading to nuclear disarmament in all its aspects under strict and effective international control. Where it says there exists an obligation, there is not a clear place in the advisory opinion where you can look back and what sort of obligation is the court talking about. Is it an obligation for all states? Is it an obligation under customary law? That is sort of left in in vague terms, except that the president of the court, president at the time Bedjaoui, in his separate statement said that it has gotten a customary nature, this obligation. So that is the closest that the court then has come. This, as I said, was the opening for the Marshall Islands to start considering litigating a case before the International Court of Justice. The Marshall Islands, the question is, where is the Marshall Islands? There is the Marshall Islands. It's a tiny group of islands in the South Pacific. If you zoom in, then you'll see that there are many islands. There's hundreds of islands actually that make up the country. It's a tiny country. It's got 60,000 citizens, which is half of the amount of citizens that the city of Leiden has. So it's not a very big state. But this is why they are doing it. They were doing it. This is the Bravo bomb that was exploded during the tests across from the Bikini Island, which is a bomb that caused part of the other islands of the Marshall Islands to become inhabitable, and there are still people suffering from the radiation-caused problems. There's still miscarriages and other birth defects, which are all caused by the nuclear explosions. And there were many of them that were conducted by the United States during that time. And for the Marshall Islands, this was the reason that they decided to try and do something about it. And they decided to bring a case before the International Court of Justice against all nuclear weapon states, and they are listed right there. There are 9 nuclear weapon states as far as we know. As you know, the court, the International Court of Justice, is a court that only takes cases of where states only appear voluntarily. The Marshall Islands did submit applications aimed at all 9 nuclear weapon states, knowing full well, of course, that not all 9 of them had accepted the jurisdiction of the court as compulsory under Article 36, paragraph 2. But it did so because it didn't want to make the impression that they would have accepted the idea that some states are able to evade a ruling of the court because they just have not accepted jurisdiction. And there is a procedure for that. States can be invited to accept a jurisdiction for this purpose, and the registrar did all of that, of course. Only China was kind enough to send a letter back to the registrar saying, we are not coming, and the others didn't send anything but didn't come either. So that's when our small team of lawyers had to conduct 3 cases, United Kingdom, Pakistan, and India. Those were the countries that had accepted the jurisdiction of the court. This is a small team for cases before the International Court of Justice. Many members of the team have contributions in that book that I just referred to, that is about the advisory opinion. The court instructed the parties way in the beginning to focus exclusively on questions of jurisdiction and admissibility, and we never got any further than that, because in this case the court decided, and again in this case there was a split vote, or there was an even vote, and it was the president who had to decide the question, and the question was decided in the negative for the Marshall Islands, because the court found, the majority of the court found, that there was no dispute between the Marshall Islands at the one hand and each of the other states at the other hand. And it's remarkable that on a question of jurisdiction, the votes would go like this, that a jurisdictional issue would give rise to a 50-50 situation, and it is also remarkable that the minority judges, many of them use very strong language in being not only disappointed but being angry about the fact that on, as they say, such formalities, the court is deciding not to go into a matter which is of great importance for the world, as most of them argued. And many of them said that the court would be has been going back to a formalism that it had tried to do away with in earlier cases. All of the dissenting opinions are interesting from the point of view of the place that the dissenters see for the World Court. I just selected one part of the dissenting opinion of Judge Benuna, who shows his disappointment, and who says, indeed, how can the court shelter behind purely formalistic considerations which both legal professionals and ordinary citizens would find difficult to understand, rather than contributing, as it should do, to peace through international law, which is the raison d'être of the court. And I think that's a very clear position, which covers most of the other positions as well. Even stronger opinion on this, and there's many academics that have been writing about this particular outcome of the Marshall Island cases. Professor Andrea Bianchi says that it makes a bad impression to avoid decisions on big cases, to stay clear of issues that are sensitive to big powers. And he continues and says, one is left with a sense of uneasiness to find out that in this particular case, the 5 judges who are nationals of the 5 permanent members of the Security Council, incidentally all nuclear powers, have unashamedly all sided with the majority to dismiss the case. Of course, this may be thought to be a coincidence, but whom do you expect to believe that this might actually be the case? And it's a serious issue. He is, in the rest of the article, he talks about a structural bias which is a very, in a way, a very friendly way, I think, of looking at things. He just said, well, the reason is that many of those judges have a background within the governments of their states, and having a background like that does not lead per se to a prejudice or a bias, but it is a background of a way of thinking which leads to this sort of conclusion. So I think it's basically it's obviously very disappointing, and it's very disappointing because it was the opportunity for the court to clarify its advisory opinion and to show the world what the solution that the court brought forward itself would be to this ongoing status quo with the nuclear weapon states at one hand and others, non-nuclear weapon states at the other hand, and no progress being made. It's too bad that the court did away with that chance to resolve that issue. To end on a more positive note maybe, but in any event on a development which shows that to many people, many civil society organizations, many states, international law is a very important tool, and as all law is usually there to protect the weak against the strong, that is true for nuclear weapons issues as well. And many states are very much in favor of doing away with nuclear weapons and making the world a safer place. The Nuclear Ban Treaty, which is a young movement, literally a young movement of people across the world, young people across the world, who were able to convince a majority of states in the General Assembly also to adopt the text of a nuclear ban treaty, which is a topic in itself. Ayalana has not been very much involved in that effort, but we have been able to make sure that the importance of the nuclear disarmament provisions of the non-nuclear proliferation treaty, the nuclear non-proliferation treaty, would be included in the preamble of this treaty, so the connection would be there, and it would be clear that banning nuclear weapons is one huge and important statement, but getting there needs to be done by nuclear disarmament negotiations. And that brings me to an end of my presentation within 20 minutes.
Thank you, Paul, for this mostly historical overview of the events that are the topic of our session today. You mentioned briefly some of the international legal aspects, the obligation under Article 6 of the Treaty on Non-Proliferation. You also referred to President Bajawi's statement that he considered, at least at the time, 1996, the obligation to negotiate the nuclear disarmament to be customary international law. We will elaborate on that, but of course it will be very interesting to hear more about it, especially since, as you already mentioned, there was not only a matter of jurisdiction under Article 36, paragraph 2 of the ICJ statute for the International Court, which, as we have just heard, only meant that the court could proceed with the United Kingdom, Pakistan and India, but there was also the issue of only the United Kingdom being a party to the Non-Proliferation Treaty and not India and Pakistan, which meant, of course, that in those cases, folks had to be on customary international law. So it's now very interesting to learn from our present colleague, Professor Meyer, the specialist in arms control law, what is actually the law in these matters. Professor Meyer, you have the floor.
Thank you, Olivier. Thank you for inviting me. It feels good to be amongst friends. Both Von der Biese and I have been involved in issues of arms control already for a long time. I recall, as you refer to, your involvement in 1984 in the case against the state of the Netherlands, and in which you even made use of my 1980 PhD thesis. I was working at the time at the Netherlands Foreign Ministry, in a different setting. Yes, thank you. Since then, both of us have been still involved in this area, but I'm now doing it as an academic. I'll just make remarks on a few of the following. Some comments I will give on the position taken by the ICJ, the International Court of Justice, both with regard to the advisory opinion and on the Marshall Islands case, and what we can learn from arms control also in the light of the recent developments with regard to nuclear weapons of both the United States in its nuclear posture review of February this year and that of Russia or the case of North Korea. Let me start by stressing that the advisory opinion on the legality of the threat or use of nuclear weapons is rich in details given its systematic treatment of arrangements in the core of conflict and security law, which is the field of my chair, which covers the law of collective security based on the Charter of the UN, with its central provision on the ban on the use of force, the humanitarian law of armed conflict, and the law of arms control. The advisory opinion thereby also demonstrates how these three sub-areas of public international law hang together, overlap. In doing so, it made some very important observations regarding each of these fields, from the use of force and self-defense, the applicability of the rules of the humanitarian law of armed conflict, from the principles of proportionality, necessity, no unnecessary suffering, to the Martens Clause, or on arms control arrangement. In that sense, the advisory opinion is a classic. But that's the view of somebody who's involved in this area at a university. With regards to arms control arrangements, our topic of today, it stressed again the fundamental rule of arms control law, namely that there is a freedom to possess weapons unless states have agreed otherwise, as also stated in the Nicaragua case. The advisory opinion was disappointing insofar as it abstained from giving a definite answer to the threat or use of nuclear weapons. As you made clear, it said that it could not conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in the extreme situation of self-defense, in which the very survival of the state would be at stake. This, of course, had to do with the policy of nuclear deterrence and showed the inherently political dimension of the case before the International Court of Justice, as was also the case in the case of the Marshall Islands. The court said, the court does not, in the advisory opinion, the court does not intend to pronounce here upon the practice known as the policy of deterrence. It notes that it is in fact that it is a fact that a number of states adhered to that practice during the greater part of the Cold War and continue to adhere to it. And also the emergence as lex lata of a customary rule specifically prohibiting the use of nuclear weapons as such is hampered by the continuing tensions between the nascent opinion juris on the one hand and the still strong adherence to the practice of deterrence on the other. In the area of arms control law, the ICJ made some interesting observations, and you presented one of paragraph 98, which you normally don't hear. That in the long run, international law, and with it the stability of the international order, which it is intended to govern, are bound to suffer from the continuing divergence of views with regard to the legal status of weapons as deadly as nuclear weapons. And then it came to that sentence that you highlighted. It's consequently important to put an end to the state of affairs. The long-promised complete nuclear disarmament appears to be the most appropriate means of achieving that result. That was paragraph 98 as you projected. In these circumstances, the Court appreciates the full importance of the recognition by Article 6 of the Treaty on Non-Proliferation of Nuclear Weapons as that obligation to negotiate in good faith a nuclear disarmament. This important pronouncement brings in the Non-Proliferation Treaty, which is central to the Marshall Islands case, for it concerns the very obligation of Article 6, namely the pursuit of negotiations in good faith. With regard to the Marshall Island case, it is of course frustrating that the International Court of Justice did not get into the merits of the case, since the ICJ decided to throw the case out based on the first preliminary objection to jurisdiction raised by the United Kingdom, based on the absence of dispute between the parties, and therefore decided that it could not proceed to the merits of the case. It introduced that criterion of awareness. I find it an interesting observation, as you mentioned that also Bianchi did, that there is a split in nationalities of judges coming from nuclear weapon states, with the exception of Judge Owada from Japan and Judge Gaia of Italy, although both come from countries that indirectly rely for their security on nuclear weapons. And they sided with the UK's preliminary objection that at the time of the application there did not exist a dispute. And the split with, on the other hand, states that did not agree with that position, who all have nationalities from non-nuclear weapon states, with the vote of President Abraham France, a nuclear weapon state, deciding. This, of course, was due to the inherently political character of the case, which is about security. Now that it is apparent that there is a dispute between the UK and the Marshall Islands, the theoretical option was that there would be a new application at the second round. The UK, however, last year excluded that possibility with regard to its compulsory jurisdiction. And now it says there's no compulsory jurisdiction in the case of any claim or dispute that arises from or is connected with or related to nuclear disarmament and or nuclear weapons, unless all of the other nuclear weapon states party to the Treaty on Non-Proliferation have also consented to the jurisdiction of the court and are party to the proceedings in question. So that option is out. What now? The question before the ICJ, however, is highly irrelevant, since it is about whether the 5 nuclear non-proliferation nuclear weapon states fulfill their commitment under Article 6 of the NPT to pursue negotiations in good faith on effective measures relating to the cessation of nuclear arms race at an early date and to nuclear disarmament. And I forget the next line, which is about general and complete disarmament, because given the right to self-defense, I think that's far way out. So this obligation of the nuclear weapon states was part of a bargain to get non-nuclear weapon states to forswear obtaining nuclear weapons. This is what brought the NPT, Non-Proliferation Treaty, into being, and this treaty can be viewed as the bedrock of the present non-proliferation regime, with 191 states parties. With the exception of North Korea, which left the treaty in 2003, though the legality of this withdrawal is still disputed, no other state has done so. Therefore, the proliferation of nuclear weapons was very effectively contained, given that India, Pakistan and Israel that have obtained nuclear weapons are not parties to the NPT. For what we can witness at present is that the opposite of nuclear negotiations on achieving a nuclear or getting rid of nuclear weapons is happening. There are no negotiations on nuclear disarmament, but at the same time the UK and France are modernizing their submarines, and more so Russia and the US are changing their nuclear strategies and modernizing their nuclear inventory and changing to smaller nuclear weapons and expressing their willingness to introduce what is in US case called, in this nuclear posture review of February, tailored deterrence strategies. The nuclear posture review says there's no one-size-fits-all for deterrence. Consequently, the United States will apply a tailored and flexible approach to effectively deter across a spectrum of adversaries, threats and contexts. Tailored deterrence strategies communicate to different potential adversaries that their aggression would carry unacceptable risks and intolerable costs according to their particular calculations of risk and costs. The risks of this development are apparent. More states party, like North Korea, might come to the conclusion that possession of nuclear weapons might be to their advantage and opt to leave the NPT, risking the crumbling of the NPT regime. There is also a greater risk that nuclear weapons might be used when the threshold is lowered or that accidents happen by miscalculation. What is the way to stop this development and bring the nuclear weapon states back to the negotiating table? Not the nuclear ban treaty, for that does not, in my opinion, not the nuclear ban treaty, for it doesn't include the nuclear weapon states. A new advisory opinion then, and how would the ICJ then deal with the security dimension? And what would be required to reach agreement on effective measures relating to the cessation of the nuclear arms race at an early date and to nuclear disarmament? Some characteristics of arms control arrangements might give an indication, namely the essential elements of security and that of verification via supervision of compliance. And that brings me to arms control law, arms control law is that area where you bring together all the arrangements that have been made on the control and use and the specific characteristics of these arrangements. And as I have already indicated, point of departure with arms control law is that there is that freedom to possess weapons unless states have agreed otherwise. There's an element which is in arms control law. There's an important role for confidence building measures. In general, there's no customary law, which also has to do with the element of security, and that element of security and verification via supervision of compliance are central. We have not seen real arms control treaties that do not, one way or another, bring a higher degree of security. States won't agree if their security is diminished. That's on the one hand. So the element of security is essential. And also, there is a crucial role in arms control law, as we can see at all these arrangements that have been made in the past. There's a crucial role if states are willing to give up, for instance, the chemical weapons, that commitment will be complied with by states. So in order to be sure, you need to have a realistic system of supervision. So these two elements, security and compliance, I think will be, supervision of compliance will be very important if we are to achieve meaningful negotiations in the area of nuclear weapons. For these are crucial for any arms control agreements that we have. Interestingly, we find the same elements in the nuclear review posture. I quote, "The United States is committed to arms control efforts that advance US, allied and partner security, are verifiable and enforceable, and include partners that comply responsibly with their obligations." Unquote. These criteria undoubtedly count for all nuclear weapon states, but will have to be realized by these very states. The only thing the ICJ might be able to do in another advisory opinion is push the nuclear weapon states back to the negotiation table. And that, for international lawyers, is a sobering thought. But it is up to the nuclear weapon states themselves to realize, and they may be pushed into realizing that by the behavior of other states, but it's up to these nuclear weapon states themselves to realize that the hands of the doomsday clock of the Bulletin of Atomic Scientists recently have been moved forward, and it's now 2 minutes before 12.
Thank you, Erik Beyer, for this overview of arms control, which you, at the end, posed several interesting contradictions. That self-defense prevents general disarmament, security versus compliance, and that also, what you found, the right to, how does the right to possess relate to the duty to negotiate? Perhaps we have time for that later on to come back to.
Just once, the general complete disarmament was about, as it says, all weapons, and the other It's about nuclear weapons.
Which is a nice bridge to our final speaker, Kees Nederlof, who was the Netherlands ambassador for nuclear security, which of course is something very closely related to everything that has been said before, especially by Erik Meijer. Because, as we have already heard, there have been some sort of negotiations on specific issues related even to a treaty which Fulfil de Biese mentioned at the end of his presentation. Kees Nederlof made certain that I would know that he is not a lawyer himself. He is an ambassador for nuclear security, but he's, as I already mentioned, he is an expert on negotiation. He knows very well what has been going on over the last decades and what is the present situation, and probably, hopefully, he can also say something about what he expects to happen, hopefully in the near future.
Thank you very much, Olivier, for your very kind introduction, very benign to my my credentials. It's a pleasure to be here back in the Asser Institute. I've been several times here in this hall to discuss different but related issues. I feel very honored to be amidst so many legal experts, and I listened with great interest to Von Biesen's introduction and Erik Meijer's comments, and I will reply to some remarks made by Von Biese in a moment, but not immediately. No matter how important legal standards are, or the ICJ opinions are, I feel the real impact on issues like nuclear weapons will only take place in a political setting. Treaties are what I call the legal consolidation of the political will of nations, and as such have certainly an important function, but in that order: first political agreement, followed by legal norms. That's one of the reasons I feel a bit uneasy about the case of the Marshall Islands against the United Kingdom. I strongly believe that the International Court of Justice is not the proper place to discuss, and even decide the nuclear weapons issue. It is an issue of wider context between the parties of the Nuclear Non-Proliferation Treaty. And there is a logical place where to discuss these issues and draw conclusions. The review conferences that take place every 5 years, preceded by so-called PrepComs, preparatory committees. Don't get me wrong. I don't say all is well, let's proceed to the established institutions as we did in the past, end of story. The Marshall Islands court case and the recent, and that was mentioned, the recent treaty on the prohibition of nuclear weapons, that is up for signing since September last year, and I will come to that issue a little bit in more detail a little bit later, are clear signs of discontent of many countries and people and international groups, and even the abhorrence on the possibility of using nuclear weapons. I understand these feelings, and they should not be ignored. Specifically, there is a wide discontent about the compliance of Article 6 of the NPT, and it has been mentioned by the two previous speakers. That article, to remind you of the content, stipulates that the parties to the treaty pursue negotiations in good faith on effective measures relating to the cessation of nuclear arms race at an early date, and to nuclear disarmament, and on a treaty on general and complete disarmament that Erik Meijer correctly said that is very far away, because it's even embedded in the statute and of the United Nations, the right of self-defense. I wish we had a magic wand to lower and even soon dispose of the large number of nuclear weapons and warheads. There are approximately 4,100 deployed warheads worldwide, of which almost 3/4 are in the hands of Russia and the United States. That's a gigantic destructive power. But one has to be realistic. There is no such magic formula to let them disappear. On the other hand, since the entry into force of the NPT in 1970, I do think significant progress has been made. And I will give you some figures. From roughly 24,000 warheads, most of them in the hands of the United States and the Soviet Union, to the current 4,100. Actually, this month marks the implementation deadline of the new START treaty, which with strict limits on the deployed warheads and delivery vehicles. I think that is a great step forward, no matter whether you think these inventories are still far too large. You may remember that former President Obama, in his famous Berlin speech in 2013, offered Russia to reduce the number of warheads by a further 1/3. That means below the current New START limits. The Russian Federation unfortunately showed no interest or declined that. So I agree with critics that implementation of Article 6 of the NPT is going slow, and that the current political situation, and notably the relations between the United States and Russia, is not very favorable to further reductions. However, and this is a point I really wanted to stress, this is not enough to draw the conclusion that parties, the US, Russia, but also the UK and the other nuclear weapon states, are in non-compliance. I promised to say something about something more about the recent treaty on the prohibition of nuclear weapons. This was a treaty that 56 countries signed up to when it was open for signature at the UN headquarters in New York, September last year. So far, only 5 countries have ratified: Cuba, Guyana, Mexico, Thailand, and also the Holy See. None of the countries with nuclear weapons and none of the NATO and umbrella countries did sign up. The Netherlands was the only NATO country taking part in the negotiations, but voted eventually against the treaty at the UN General Assembly last year because it concluded its proposals had not been taken care of. Do I think that that treaty was an understandable reaction to the current state of affairs of disarmament? If you would say so, a cry of despair. Yes, I do. Do I think that the treaty was a clever instrument? No, absolutely not. The initiators of the treaty were simply uninterested to get the nuclear weapon states on board. But on top of that, it failed to include any verification mechanism or intermediate steps towards nuclear disarmament. What's more, the text of the treaty runs counter to the only really global nuclear treaty, the NPT, and that was already mentioned several times. And it did not include or promote, for instance, the Comprehensive Test Ban Treaty that is so important for the Marshall Islands in its operational paragraphs. It did mention it, but not in the operational paragraphs. A missed chance, in my opinion, is also that the negotiations on a fissile material cut-off treaty, so-called FMCT, have not been supported by the ban treaty, let even be incorporated in the text. And a number of other lacunas that this audience will find annoying, like the absence of definitions. It's a treaty without clear definitions. I'm quite aware that I presented you a bit of a gloomy picture: stagnation in nuclear arms control negotiations, worsened relations between the US and Russia, not to speak about North Korea, nuclear ban treaty out of despair and things like that. Still, I see some hopeful signs. Firstly, the United States took the very important initiative in 2015 to create an international partnership for nuclear disarmament verification. International Partnership for Nuclear Disarmament Verification. For the first time in history, non-nuclear weapon possessing states were invited to explore disarmament verification measures, to further understand the complex issues of how to verify arms control agreements. A kind of preparation for better times and future agreements, tapping the experience of a wider group of countries, and which is very important, saving time to solve some of the most difficult challenges during future negotiations. More than 25 states participated with technical and political experts, including the Netherlands. There are several here in this room I detected that have been actively involved in those discussions. The Russian Federation and China were of course invited, but chose to attend as observers. The first phase of the project has been concluded and the results shared on the official website. And you can look it up, just Google IPNDV, and all information is available. Secondly, in Geneva at the Disarmament Conference, preparatory work for a future fissile material cut-off treaty is continuing. Such a treaty would ban the production of fissile material, which means highly enriched uranium and plutonium, for nuclear weapons, thereby contributing to a gradual decrease of weapons. And this includes, and this is very important, this includes the nuclear weapon states. All states except Pakistan have agreed to start the actual negotiations, Pakistan fearing an advantage of India. However, since the estimated number of warheads of India and Pakistan is now roughly equal, we may see a breakthrough in the near future. We may also see a gradual improvement of US-Russian relations after the Russian presidential election next month. Nobody, I think, has any doubt that current President Putin will be re-elected, and he might then be in a more favorable position to consider offering the US a kind of reset of its relations. President Trump anyhow spoke out in favor of improved relations with Russia, so you might have a two to tango. There are other developments like the House of Representatives elections in November this year that might bring back the Democrats a majority, but that's a more vague and promising issue. I promised to say something about a remark that Van Wiese made when he referred to the litigation against the Dutch state. And like my then colleague Erik Meijer, I was working in the Ministry of Foreign Affairs at that time, what's more, in the NATO department. We were not yet in that building that you know is very close to the Malieveld where the big demonstration took place, but we were still working in the, I would say, very beautiful building at the Plein 23 here in The Hague. That was an interesting remark you made, but it's not the whole story. It's the Netherlands did not simply take a decision to deploy the nuclear weapons or the cruise missiles, but together with its NATO allies, challenged the Soviet Union to stop deploying its SS-20 missiles. And only if the Soviet Union went on, the Netherlands and its allies would deploy the weapons. Hence, it was a conditional deployment. It was the famous NATO double-track decision. And it worked. It worked. This eventually triggered the famous agreement between Gorbachev and Reagan, which led to the INF Treaty in 1987 to completely prohibit, ban the intermediate range nuclear weapons. That story supports my statement that you first need a common will of nations, which eventually will lead to a treaty, not the other way around. And I strongly believe that it's not a court case that will eventually bring about nuclear disarmament. It's the facts on the ground between nations. I come to my conclusion. There has been significant progress in nuclear arms control since the NPT came into force, leading to a dramatic decrease of nuclear weapons. I'm aware that many states think this is not enough and that they try other avenues. However, there is no magic formula for disarmament, and this doesn't replace the tedious arms negotiation progress. I told you there are some hopeful signs like IPNDV and FMCT and possibly future changes in the political landscape. Thank you.
Thank you, Kees Nederlof. The presentations took a little longer than expected when we started. Before we go to the questions from the audience, there's someone with the microphone waiting. I first want to give our speakers the chance to very briefly react to the other speakers if they want to. Otherwise, we go directly to the audience. Any of the speakers want to say anything about what they just heard? Briefly?
As you know, I can be very brief. Just, I don't have any response to Eric's presentation. I think it's no problem whatsoever. And I'm glad that you reminded me that we used your PhD for our first nuclear weapons case, because we need to have academics that write about this and provide support. I agree with Kees Nederlof on most of his remarks on the ban treaty. Because I agree that law is not formed by majority vote, and the fact that many states are in favor of a ban treaty and are willing even to sign a ban treaty doesn't mean that once they have the majority that is the law, and I think that is in the concept of the banned treaty an important mistake. At the same time, there is a connection with the obligation to nuclear disarmament made in a very late stage of the drafting of the treaty, and I think that makes it important to make use of the energy, and that's something. I mean, the banned treaty is produced as a result of an entire new generation who wasn't even aware of the cruise missile cases and related issues, who have realized the abhorrent effects of nuclear weapons, and that movement as such is very important, and it's important that states pick up on that. But I agree on the legal technicalities that is not in itself going to be the way to go. Final remark, you said it's not first a treaty and then the practice will follow, but it is going to be the other way around. That is, I consider that to be focused mainly on the banned treaty, that remark. The Non-Proliferation Treaty, of course, is a treaty in existence. The court had spoken about that in a very meaningful manner from a legal perspective, providing a real view on a possible next step of the court with the Marshall Islands case. The Marshall Islands did not ask anything else from the court than to establish that the defendant states were in violation of their legal duties, both from the treaty and from customary law, because there are no negotiations going on at all. That was the first step of the claims in the Marshall Islands case, and the next step was that we asked the court to order the defendant states to initiate and to participate in negotiations as foreseen in the Nuclear Non-Proliferation Treaty. So there was not a claim aimed at let's make the treaty here in court, but it was aimed at living up to an obligation which has been forgotten almost by most of the nuclear weapon states.
I see that the microphone here is still on, so I can have a better overview of the audience. There's a microphone in the back. Anyone I can give the floor with a sort of, please try to focus a little on the legal issues and not make longer statements, etc., because we're running a little late. Thomas Vervoes.
Thomas Vervoes, journalist for justice. I will be very legal and technical and not make political statements.
Thank you, Thomas.
Just a question of clarification. You explained to us how the Marshall Islands versus UK case has been thrown out because of that admissibility problem. No, there is no issue between the parties. But what happened to the two other cases? Because they were formally separate. Did India and Pakistan raise the same preliminary objection? And if not, on which other ground have they been thrown out, if they have?
The issue of is there a dispute or not?
Pakistan was very brief. It only sent a letter to the court, a very angry letter, in which it said that they were the wrong defendant to be chosen by the Marshall Islands. And they said, we are all for nuclear disarmament and we are playing our role to that end. India did appear and did appear during the oral pleadings also, and they repeated for 1 day or 2 days in a row we are on the same side as the Marshall Islands, because we have been voting in favor of all sorts of nuclear disarmament resolutions, but we can't do it alone. And therefore, in those two other cases, that was not a split vote, but it was a majority vote in favor of the finding that there was no dispute between the Marshall Islands and those two countries.
Wasn't there a very interesting remark at the court in all three judgments that said dispute, the parties must be aware of the dispute or not non-aware of it? But a very
that is the crucial finding, basically, in all three of the judgments. First, the court spent quite some time in explaining that there is no legal obligation to notify your opponent in advance that you have a dispute between you, which was in accordance and to be expected in accordance with the case law of the court. But then the court came with this awareness concept, which is totally new, and in our view is very similar to an obligation to notify. It's you need to be aware that you have a dispute with the other side, or cannot not be aware of it. In other words, the other side has been making it totally clear to you that there is a dispute, which brings us back to the notification obligation, which did not exist. If you're still with me.
I saw a hand here. Mr. Chowdhury, very brief, please.
I thank you both professors for helping us to understand about nuclear disarmament. But my question goes to the Ambassador Netherloof. Ambassador, some time ago, I defended Pakistan's nuclear test while sitting in front of Paul Witteman in the program Buitenhof because of the nuclear deterrence against second largest country population-wise and dozens of times bigger country, India, which has never ever accepted Pakistan as a sovereign state, but I have always been trying to create instability against Pakistan. So that's why Pakistan had to go for that. My question to you is, don't you think that there won't be ever any nuclear treaty, disarmament treaty, unless United States of America and Russia are ready? Because putting pressure on Pakistan, countries like Pakistan and some other countries who are already facing vulnerability and security threats to their existence, I don't think morally, ethically, legally it is it's a right thing to do. Thank you.
Well, the matter is not so much that we might expect a nuclear disarmament treaty without the United States or the Russian Federation. It's a matter that we should not go beyond the current countries that possess nuclear weapons. The more you have it, the more unstable the international situation is becoming, and the most famous case is now North Korea. How much this was threatening the peace in East Asia. The same is true between India and Pakistan. Especially in the building up phase of nuclear weapons, a very unstable situation exists. Yes, it's a fact of life. It's the same as when you would say, yes, it's a fact of life that Israel most likely has nuclear weapons, but it doesn't mean that this is a very favorable situation. And what Pakistan and India should do is to conclude a bilateral agreement to minimize the threats. They have some negotiations and agreements between the two, but there should be a much firmer treaty between the two countries. Thank you.
Which suddenly reminds me of a rumor that President-elect Trump, when briefed about the security situation, asked, "Why do we have nuclear weapons if we cannot use them?" Anyone? Yes, the lady at the window.
Thank you for your speeches. I'm Soumya from Utrecht University. I'm a student here. And my question is, I'm actually confused between where the balance lies in state sovereignty and their choice to not engage in negotiations, and the obligation under Article 6, especially on states not parties to the NPT.
Professor Meyer, arms control law. Microphone, please.
Yes, you ask about the balance between
the sovereignty of states and their choice to not engage in negotiations, and the obligation of conduct as well as of result, especially on states which are not parties to the NPT.
Yes, well, for states that are not parties to the NPT, of course, they're because then you're talking about nuclear weapon states like Israel, Pakistan, India, but they don't have any obligation under the NPT treaty. You might say there is a customary law obligation, but that's still being disputed. The others, for the nuclear weapon states that are party to the Non-Proliferation Treaty, and these are the five, and the same five Security Council members. Well, that's the question. They have an obligation to negotiate, but they don't actually sit together as five around the table to do so at this moment. So whether it's their sovereign choice not to, but they should, because they as the International Court of Justice made clear, because it's an obligation to achieve a certain result. So one way or another, they should do so. So that's the difference between the non-NPT member states and NPT member states.
And the argument, of course, was that customary international law has come into existence mainly due to the repeated decades-long acceptance by the General Assembly of resolutions calling on states to engage in these negotiations, with that result to be reached and achieved. Already, as mentioned by President Bajawi in the advisory opinion in '96, but also, of course, repeated by some judges in the Marshall Islands case, especially in the dissenting opinions and separate opinions. How would you judge that? Do you think that there's a good argument for that? Customary law has come into existence to that effect. I know that I see the finger of Von van der Biesen. I know what he will say, but first Professor Meyer, or maybe Von van der Biesen first, if you want to think a little later. Yeah,
I'm not sure whether that's already the case. The '96, as far as your opinion, was not clear on that.
No, but now we are a bit further in time.
Well, just very briefly, obviously that the question whether the obligation to negotiate in good faith and bring to a conclusion nuclear disarmament, whether that is indeed an obligation under customary international law, has never been decided before, and that was one of the main issues of the Marshall Islands case. But we did, and we haven't been arguing that at length because we didn't reach the merits stage, which is a shame also from that perspective. But it is interesting that since the advisory opinion was delivered by the court, each and every year there is a resolution adopted by the General Assembly with the support of the states that do have nuclear weapons. Almost all of the states, not all of them, do have nuclear weapons, but are not part of the NPT, which called upon all states to start the negotiating, which was, according to the court, an obligation. And that is very much in support of the idea that that is an accepted part of the opinion.
And of course, since the Nicaragua judgment, we know that according to the court, repeated voting in favor of specific resolutions, also in the General Assembly, even though those resolutions are not binding by itself, can produce a sort of legal result which the states voting in favor can be held accountable for. You have a follow-up question?
Yes. Adding to that, in the Nicaragua case, the court also said that specially affected states should particularly take part for the creation of customary international law. In this case, do you think the states possessing nuclear weapons are specially affected, or the criteria of specially affected states does not apply here in the case of nuclear weapons?
You mean because we would all be affected?
We would all be affected, okay. Yeah.
Well,
I think there are no specially affected states. All of us have the same great interest in ridding the world of nuclear weapons. And that's true for all people, and it's also true for all states.
But there would be a difference between the nuclear weapon states and the non-nuclear weapon states, wouldn't there not? In terms of states and sovereignty and positions internationally.
Yes, but one of the things that we try to stress in the way that we have designed the Marshall Islands case is that we don't want to make the impression that the obligation to negotiate nuclear disarmament is something that belongs to the nuclear weapon states. And so that's a separation that in practice has been made very often when people say, well, it's like was said here before, it's first the United States and the Russian Federation that needs to come to a conclusion together. Well, it would be helpful if they did, but it affects all states in the same manner that they are not doing that, and therefore it's in the interest of all states, and there is no difference between the states.
And all states party to the NPT.
And the others as well.
You could turn it around. You could say negotiations without the participation of the two biggest nuclear weapon states are simply futile. It's not a matter of, that's not a legal argument, but that's not my profession. But it's a fact of life. If you do not have the support of the two major nuclear weapon states, the United States and the Russian Federation, you can do whatever you want, but the effect will be not what you expect.
Thank you. If there are no further questions, Thomas, well, you have the last word, Thomas.
The Geneva Conference on Disarmament has been ongoing for decades, and I think if you ask a simple Dutch citizen in the street to cite an example of what it has achieved, he or she would probably find it difficult to name one. You are, of course, an expert. Could you cite us one or two successes you have seen there in the past years?
Well, there are certain treaties that have been, started in Geneva, and I think the
Dubious weapons.
yes, the Dubious Weapons Convention, that have made a result. The fissile material cutoff treaty that I referred in my introduction has not yet appeared in the results of the Conference on Disarmament, but it's indeed a very promising type of negotiations that once Pakistan will do away with its veto on tackling that issue, might come to results. But you're absolutely right. It's not a forum that is full of achievements and successes, unfortunately.